have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Okay, I understand the Applees are splitting their time. I'm not even going to try to figure it out. You're responsible on the clock.
Yes, sir.
Go for it. You may proceed when you're ready.
Your Honor. I'm Sean Frazier from Parker Hudson Law Firm, joined by my colleagues Kristen Bond and Mark Ito. May it please the court. I'd like to reserve 4 minutes for rebuttal. We're here on the court's de novo review of the constitutionality of a law governing the approval of new trauma centers or the elevation of those trauma centers to differing levels. Miami-Dade's service area for trauma programs has been well served for many years. It includes two well-regarded, in fact, internationally renowned trauma centers. One at Nicklaus Children's Hospital that offers a pediatric specialty trauma center, and another at the world-renowned Ryder Trauma Center in Jackson Memorial, a level 1 trauma center that can accommodate not just everyday trauma, but high-level burns and pediatric patients as well as adults. In 2011, Kendall joined the fray and became a level 2 trauma center, an initial phase of trauma center that could not treat pediatrics or burn patients. But in 2016, they applied to elevate their trauma center designation to level 1 so that they may for the first time seek to serve pediatric patients.
Let me cut through the forest or wherever and get down to it here. Is the legislature permitted to draft a reasonable classification, even if that classification only includes one person?
The legislature is permitted to create a classification, but if the class is closed and it can only apply to one person, then it is an unconstitutional special law.
Even if it's a reasonable class and there's a good reason for doing it?
There are 2 tests that apply, Your Honor. The first test applies to general laws that are in the guise, that are actually specialized in the guise of general laws. That test does not actually encourage or require the court to look at statewide impact or importance or the rational relationship of the special designation to that statewide impact or importance. That only comes up in the context of local laws.
Well, if I have a new application process that I'm putting into effect, and trauma centers are a limited number of people, and if I have a new classification or application system for trauma centers, and somebody's like 99% through, I'm not saying they're 99% through the process, but let's say somebody's 99% through the process, and I, as a legislature, I say, this new trauma system is really, really good. But it's going to be unfair to that one person that's 99% through the process not to exempt them. Would that be a special law which would be prohibited without notice? Or would that be granting, as you argue here, privilege to one particular corporation?
It is granting privilege to a private corporation, and it would be a special law. There'd have to be some rational basis for that designation of one particular hospital.
I understand the rational basis, but I thought I put up a pretty good rational basis for doing that classification. All my questions are going, assuming there's a reasonable basis for the classification.
I don't think you ever get there, Your Honor. The test applied by the Florida Supreme Court is one applying to general laws and special laws in the guise of general laws. The 16C provision we're here to discuss today makes no geographic descriptions.
Can we look at 16C without looking at the entire section 16?
I'm sorry, I couldn't hear you, sir.
Can we look at just 16C in isolation from all of section 16? Forget about looking at the entire statute for a second.
Yes.
But don't we have to look at the entire section 16?
Nicklaus Children's Hospital is only affected by 16C. There may have been giveaways to other special...
I understand, but didn't that all of section 16 affect a number of different hospitals that were partially through the application process? Didn't that affect all trauma centers?
Yes, 16C talked about some existing providers in the context of 395.402, which also had limits on approving any new providers. They all work in concert together, but to get back to the test that applies to the law that we're talking about, 16C made no geographic limitations. So it is not a local law, it is a general law, a special law in the guise of a general law.
Didn't the Constitution basically say local laws and special laws are the same thing? I mean, well,
here's why it makes a difference.
It seems to me, we came up with this whole thing with local laws when there was not home rule for local governments and things. So we had this quote-unquote classification of special laws and subclass of that being local laws.
Is-
Isn't that kind of the history of this?
I've looked into it a little bit, Your Honor, and I think you're asking whether we should apply the test that applies to local laws to general laws that are really special laws in the guise of general laws. What we have here is a statute that describes a situation that on its face could be applicable throughout the state. Existing trauma centers that have been provisionally approved and were operational by a certain date and time. But when you look at the facts, that general law is not a general law. It's a special law that applies to only one entity, Kendall. No other person can apply for that class. The class is closed when it was created.
I
You look back
understand that,
retrospectively.
closed classes, and we haven't been good with the language in some of our cases, but closed classes that have classifications that are not reasonably related to the purpose of the statute, that's a local law.
That is a
It
local
seems
law,
like
and that's
you're
the test that
skipping-
applies to
you're
it.
skipping- It seems like to me you're skipping over a step here where there's a reasonable classification.
Your Honor.
That is in fact a general law.
What the steps I'm following are the steps set forth by the Florida Supreme Court in license acquisitions and in the Gulfstream case. When you have a local law that's in the guise of a general law, the inquiry begins by asking, was there notice provided or was a referendum provided for? That answer is clearly no, so the next question becomes, is this a special law with a closed class that applies to no one else? That answer in this case, again, is yes, this only benefits Kendall. It's a closed cast. Nobody can question
Guys,
that.
let me-
And the Supreme Court cases end their inquiry there. They do not move to the next step of asking whether it's a local law. And if I may explain just briefly, the reason's kind of relevant. If it's a general law that nobody can tell really benefits a local law, well, then it's going to be found in violation if it turns out this is a closed class, you guys are trying to get away with a ruse. But if it's a local law, what everybody in the world sees, this is from Monroe County, or this benefits another person, then you do a next step and say, is it a rational basis to give this local benefit in context of greater statewide impact and importance? Again, we're not in that situation because
Council, let me ask you, try to approach a question Judge Wolf asked from a different angle. I had occasion to research a statute recently. It was about 120 years old or so. And, you know, in those days, they had all kinds of different classifications of things, and they didn't really set them off with subsections and paragraphs and subparagraphs. They just set them off with commas, you know, just one big section which covered a whole bunch of different things. So what if the legislature here just had paragraph 16? If you're an existing level 1, level 2 pediatric trauma center, if you're a provisionally approved level 1, level 2 pediatric trauma center, then you don't have to go through the qualifications provision of this. What if that were all in just one subsection? Would that be permissible?
no, it'd still be invalid, and it would fall into the cases like
Well, it surely would. It would cover, I believe, every single trauma center in the state.
only a few would qualify for the exemption if 16C included lots of different things, just like the whole trauma revision
But how
2018
about the
included lots of
reasonable
different things.
classification? You keep on trying, how about if the reasonable classification they're drawing only consists of one person? Does that preclude the legislature from drawing a reasonable classification if it's in line with the purposes of the statute?
In the context of a local law, the legislature may direct something that benefits a
But you
particular
keep on
person, but
skipping
it
over.
must relate to the statewide
Because if
impact.
it's a reasonable classification, counsel, isn't it a general law?
It's a local law. If it's you're asking, can't we apply the local law test to general laws that are?
No, what I'm asking is, isn't if a legislature draws reasonable classifications based on the purpose of the statute, do we even get to the local law analysis? Isn't that in fact a general law?
I don't agree, sir, no. And if I may, I'll suggest what the statutory analysis really is and should be, and even get to, if you did apply the statewide impact and importance analysis, which I don't concede should be applied here, this statute fails it. There's no record evidence that there's a benefit that's conferred to the statewide trauma system by approving Kendall and allowing them to serve pediatric patients instead of an existing provider that was ably doing the job. There's no statewide impact or importance. We may talk about
So
an
anytime I
inclusive trauma
grandfather
system.
something in, that would be a local law?
I'm sorry, sir.
Anytime I grandfather in 2 or 3 people, because that would be still a closed classification.
It can
So
be.
that's a local law?
And they've been found invalid, such as in the case of Martin Memorial versus Tennant, when a CON exemption was given away for open heart surgery programs that only benefited a few counties. And again, was found invalid in St. Vincent's when a CON again was given away. and it was found that only one hospital could benefit from
Well,
that,
St. Vincent's,
even though cardiac regulations
I think I was
important.
on St. Vincent's, I don't remember, but I think I was. Isn't that where there was no reasonable basis for the classification that was being drawn? It was just, the classification was set up to just give
Exactly like-
benefits to one particular hospital.
That's correct, exactly like this case. This 16C, the only thing we have standing to challenge, and did challenge, benefits one hospital only, Kendall. And there's no explanation in the record why that is a benefit to the inclusive trauma system. When we talk about an inclusive trauma system, we talk about trauma systems that include each other, report data, share and improve research, coordinate with first responders and with referring hospitals. That's what we mean by inclusive hospital system. But what matters to Nicklaus is the approval of Kendall down the street. That is a local benefit to them and them alone. And the approval of Kendall does nothing to improve trauma service delivery in Tampa or in Jacksonville or in Ocala. It's simply a local law for their benefit. I do want to just make mention that this is also, we're not only challenging pursuant to Article 3, Section 10, because it is a general law, a special law in the guise of a general law. There was no notification, and it only applies to a closed class of one. We're also challenging because this violates the constitutional provision that prevents private corporations from getting a special benefit from a law. Again, this only benefits Kendall. It does nothing for the trauma system as a whole. It only inures a benefit to them. Now they get to see all the patients south of their facility instead of us. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you. Okay, guys, divvy up your time.
Good morning. May it please the court, I'm Amber Nunnally from the law firm of Schutz & Bowen on behalf of the Florida Department of Health. Your Honor mentioned that we are splitting time today. I will take just 4 minutes to briefly discuss the comprehensive nature of the 2018 amendments to the trauma statutes and why they're a constitutional general law. Then I'll be followed by Raul Cantero on behalf of Kendall Regional Medical Center. And with any remaining time that we have, Angie Gonzalez is available to answer questions on behalf of Jackson South Medical Center. In 2018, the legislature passed a comprehensive overhaul of the regulatory framework for the state's trauma system. This overhaul made numerous revisions to multiple sections of Chapter 395. The most significant changes included redesigning the trauma center application process, establishing a formula for how the need for new trauma centers is determined, and reorganizing the counties that comprise the 18 trauma service areas in the state. As part of this comprehensive overhaul, the legislature established the licensure status of all 35 of the state's existing trauma centers, including the 3 hospital parties in this case, to ensure that the existing system of trauma care was uninterrupted. Nicklaus is now
Okay, is
asking—
this really a grandfather clause? I mean, you say uninterrupted, and I understand the idea of a grandfather clause, but was this really truly a grandfather clause to keep the system running the way it was supposed to?
I don't know
A true
that—
grandfather clause to me would have said you're not subject to the new rules for the application. But they didn't have to go that extra step and say your application is granted before you go through the administrative hearing process.
I don't know that we characterize it as a grandfather clause. Kendall was operating as a provisional level 1 trauma center at the time these amendments were made.
And I understand, but they had not a provisional. They had not received
Right,
their final.
they had not completed the prior application process at the time that these amendments were made.
So what's the benefit to the state of pulling them out of the administrative hearing process?
Well, in Chapter 395, the legislature has expressed that the importance of having an inclusive and integrated trauma center, but also in ensuring the viability of existing trauma centers. So, like I said, at the time of the 2018 amendments, Kendall was operating as a provisional level 1 trauma center. So converting their provisional level 1 status to a verified level 1 status as part of the overhaul of the state's trauma center is rationally related to that function of regulating trauma care to promote public health. And doing that ensured consistency in the trauma care provided to the community that was already being served by Kendall, which the legislature determined was vital importance to the statewide system. The few cases cited by Nicklaus about statutes that created closed classes are not applicable to the 2018 amendments to the trauma statutes. Those statutes are fundamentally different than what was done here because they were narrowly focused to provide special benefits to one or a limited number of entities, and, as Your Honor noted, they were not rationally related to an important statewide purpose. Subsection 16C and subsection 16 as a whole bears no resemblance to the statutes that have been invalidated in the past as special laws. And so
What if they picked out 4 trauma centers and carved out exceptions for those 4? but didn't address all the other trauma centers. And there really wasn't, I couldn't figure out a purpose for carving out those 4. Just because they dealt with 4, would that make it any less a local law?
Well,
that's the argument the other side's being made.
If that were the case, that may be a tougher situation for us to argue that it wasn't a special law, but we don't have to address that here, because here there was a comprehensive overhaul to the entire trauma system in the state, and the changes that were made affected all 35 of the trauma centers throughout the state and all geographic regions of the state. And we aren't dealing with simply exempting 4 trauma centers from the ongoing licensing process, like your hypothetical noted. I see that I'm almost out of my time, so if there are no further questions, we would ask that for all the reasons we've discussed here and in our brief, that you affirm the final summary judgment. Thank you.
Thank you.
May it please the court, Raul Cantero on behalf of Kendall Regional Medical Center. To read the briefs of Nicklaus Children's Hospital, you would think that the only thing that was involved in Chapter 2018-66 was adding paragraph 16C to a statute. But in fact, this was a comprehensive change to the way the trauma system in Florida is administered and the way that trauma centers apply to become trauma centers and limitations on the number of trauma centers. While they don't talk about it in their briefs, there are 12 different statutes that were amended in 2018-66. And as this court said in the Scherer case, not a special law, general law case, but a statutory interpretation case, you need to take all of the subparagraphs of a law together because it's part of one comprehensive scheme. And this 2018 trauma law was designed to comprehensively change the trauma system in Florida.
I understand the comprehensiveness and the need to go forward for the future. This is going to be the system. How does this specific exemption for you relate to the comprehensive system going forward?
The specific exemption in 16C is part of the exemptions of all of paragraph of section 16. They all, except for 16A, which concerns the verified trauma centers in Florida, every single subsection from B through F relates to particular trauma centers in Florida. And what they wanted to do was say, we're going to another scheme, kind of like what happened in other cases. We're going to a different scheme of a system. We need to make sure that these who have already invested substantial sums in becoming provisional trauma centers and have exercised everything that they had to do in order to become verified trauma centers have that opportunity to do so. Because
do we really know that they had done everything? I mean, there was a
yes, we do.
There was an administrative challenge going on. I'm
Right.
not saying they should have been subject to the new law. But
There's an
that's the whole idea behind the administrative proceeding, to decide whether
Right.
they had satisfied them.
yes, and this court, this is the same situation that this court encountered in Lakeland Regional Medical Center, where there were certain, I think it was hospitals, grandfathered into a statute, and a hospital contested that and said, you're grandfathering in. We had an administrative challenge. This violates due process. This violates equal protection. And this court says, no, this was, you don't have.
They talked about due process and equal protection. It was not.
Right, right.
Not
We're talking about whether it's a special law, but that all goes into the analysis if they're arguing that we can't be grandfathered in. If that's the argument, well, grandfathering in doesn't relate to whether it's
No, but as I
special.
pointed out to Ms. Stoner, this is not a true grandfather to me. A grandfather to me is, this new law is not going to affect you. This one went one step further. It said, this new law is not going to affect you, but we're also granting a license here. Isn't that a little bit different than your classic grandfather clause?
It is, because certain of the trauma centers were in different circumstances. For example, Kendall had completed everything it needed to do to become a verified trauma center, It went through the provisional process, it went through the in-depth analysis and passed that, and then it went through the on-site survey, which is the very last thing that you have to go through, and it passed the on-site survey. And the only reason that it didn't become a verified trauma center was because of the administrative challenge. But there are other, if you look at subparagraphs 16E and F, there are other trauma centers that had to do a little bit more to become verified trauma centers, and if they completed those steps to do that, then they would do it. Then they would become verified trauma centers. That's why it couldn't just say, everybody here is grandfathered in. Also, they needed to make sure that the ones that had invested all those resources were provided the vested rights that they had by investing that, because
No, I'm very sympathetic. I mean,
yeah, no, and also
But that-
remember that another change to the statute, which is what Nicklaus wants to rely on, is the change to addition to 395.4021B. And what that does is it prohibits a new level 1 trauma center from being admitted in a TSA that already has a level 1 trauma center. So Nicklaus's
No, I
argument.
understand that, and I
Yeah.
understand the reasoning behind the legislature of saying, okay, that section doesn't apply to you.
Yeah.
The only question that I have is the additional step of why couldn't they let your client continue to go through the administrative process to see whether they actually met the licensing requirements?
Well, perhaps they could, but the question is not what they could have done, but whether what they did do is constitutional and makes it a special law or not. And I don't think it does. And in their briefs, Nicklaus conceded that this court's case of R.J. Reynolds versus Hall is an example of a case where it wasn't limited geographically like the other cases, but the court said this is an issue of statewide importance where we've granted limitation on supersedious bonds to 5 specific tobacco companies, and those 5 tobacco companies will never have to post supersedious bonds greater than $5 million. It may be less depending on a formula that's in the statute. And plaintiffs argued that that was an unconstitutional special law, and this court said no, there was an important statewide interest in obtaining the funds from the settlement agreement that those tobacco companies had signed in 1997, and if they have to post $1 billion worth of supersedious bonds, they may not be able to make the payments under that settlement agreement, and the state will lose that money. So this is an issue of statewide importance. Now, I haven't heard Nicklaus arguing that this 2018 trauma law, taken as a whole, is not an issue of great statewide importance. Of course it is. It has to do with a comprehensive change to the trauma system and trying to make it a statewide trauma system.
Let me kind of veer off course because I found one argument in the briefs a little bit interesting. I'm not sure I buy it, but a little bit interesting about the severability clause. I've always looked at severability clauses as being, okay, legislature's told me if I shoot it out, won't disconnect, won't, if I'm one part bad, the whole thing goes. This whole idea that shows a legislative intent that this be a general law versus a special law. Could the legislature put a whole bunch of special laws together and just say severability clause? Therefore, it's not a special law anymore?
Not if they're disjointed, Your Honor. But here, they all relate to the same subject matter, the same
I understand
trauma.
that. I just saw a lot of space being wasted on the
Right.
severability, and I'm not sure I understood that argument from either side, actually.
Well, the reason the non-severability clause is important is because there are various cross-references in other changes to the statute to Section 402516. For example, the one that I cited to you earlier saying you can't open up a new level 1 trauma center in a TSA that already has a trauma center says except as provided in 402516. So if you throw out 40516, then that statute can't apply either because it's designed to work together with Section 16. That's why this non-severability provision is so important. It's all interconnected. You can't take out one and leave the rest untouched.
Is that always going to be the case with a non-severability clause? I mean, what if the statute here basically just, you had a comprehensive system in the law and it said, subsection, Kendall Regional Medical Center is not subject to any of this. Oh, by the way, we have a non-severability clause, so if you find the special law, then you have to strike the whole thing down.
I don't think it's always applicable, and I'm not arguing that there's a general principle that you should always respect non-severability clauses. I'm saying that under the circumstances of this case, where everything is so interconnected, and especially because there are so many cross-references to 402516, that intent is that we can't take out Section 16 either in part or as a whole.
I think both Judge Winokur and I both buy the argument that we have to read the statute as a whole and look at the interconnected
And I think
relationship.
as long...
We're just trying to figure out the legal effect of the severability clause.
Yeah, well, and as soon as you do that, Your Honor, you don't have to get to the non-severability clause. Because when you consider the statute as a whole, as you should, it's very apparent that the statute as a whole relates to every single trauma center in the state and the entire trauma system. You can't take out one paragraph of one section of one chapter law and say that is a special law. You have to take everything together that was enacted together to determine that. The last point I would like to make, and I don't think I'll leave any time for Jackson South, but
if you'd really like to talk, I'll give you 3 minutes when Mr. Quintero's through, and I'll give the other side 3 minutes.
Thank you. The only other point I want to make is to address Article 3, Section 11A12. That statute is irrelevant here, no matter how you rule. Because if this is a general law, then 11A2 doesn't apply. It only applies to special law. And if you say that it's a special law, then 11A2 doesn't apply because the legislature didn't comply with the requirements for a special law in the first place, and so you don't get to 11A2. It's unconstitutional under Article 3, Section 10. So under no circumstances is 11A2 relevant to the analysis here. And I think you should affirm the judgment. Thank you.
Okay. Would you give the, I'm sorry, I don't know your name, but 3 minutes.
Thank you. May it please the court, my name is Angelina Gonzalez. I represent Jackson South in this case. I'm from Panzamauer. I wanted to address a couple of points that have come up through this discussion. And one of the questions that Your Honor had was regarding the grandfather clause. And I really want to talk about the case law that surrounds the grandfather clauses. The Florida Supreme Court in Hartman Transportation v. Bevis has specifically held that grandfather clauses are favored in the law because they tend to protect rights either existing or in the process of being obtained prior to cutoff dates. That is critical because we have seen this be applied in other cases as well. Counsel referred to the Lakeland case, and I actually wanted to, and I do have copies if you would like to see it, but I wanted to read a portion of the grandfather clause that was at issue in the Lakeland case. What was being actually challenged is the portion that said existing providers, any provider with an exemption for open heart surgery, and any provider with a notice of intent to grant a certificate of need or a final order of the agency granting a certificate of need for adult interventional cardiology services or burn units shall be considered grandfathered in and shall receive a license for their programs effective on July 1st, 2004. I believe that the court is aware of the certificate of need process, but I do want to highlight a few points. The trauma system, the way it was before 2018, and the certificate of need system are very similar, were very similar at that time. Having a notice of intent to receive a certificate of need is analogous to having a provisional license in the trauma world. And in this particular case, the notice of intent to issue certificate of need was being challenged by Lakeland against West Haven. And so the whole issue surrounded the fact that there was a hospital that had a notice of intent or a provisional certificate of need, and the hospital was challenging it. This court held that despite the fact that there was a pending administrative action, the legislature could still grandfather in these programs because of the fact that the administrative action does not create a property right for a party. So, and that's a specific case law. There's another case that I would like to cite to, which is called Hartman Transportation v. Bevis, which was decided by the Florida Supreme Court. It is also very similar in the sense that these are also certificates that are issued in the transportation context. And the issue in that case was whether the grandfather clause could be applied to parties that had applied for their certificate by the cutoff date, or if it only could apply to parties that already had the certificates by the cutoff date. And the Supreme Court held that the petitioner had duly filed application for Charter Party Rights Authority on the stated routes prior to the cutoff date and had expended money and effort to secure the authority it later received, and therefore found that this grandfather clause could be applied to individuals that were in the application process and had already expended resources to get them.
Okay, your time is run, thank you.
Thank you. I appreciate the time, and I ask that you all affirm the judgment. Thank you.
Please, the court. Just a couple of items to address from the appellees. First, Lakeland Regional did not involve a challenge to the constitutionality of a special law. It instead involved constitutional issues of due process and equal protection, so it doesn't contain the analysis that we're here to talk about. I also want to revisit that analysis and the standards and answer your question, Judge Wolf. In the license acquisition case from the Florida Supreme Court, the court noted that whether the class is potentially open is the dispositive fact in determining whether a reasonable relationship exists between the classification and the law that's under challenge. It is for general laws.
Clearly, that's one factor, but don't we have to look at other factors to determine whether
The
it's a
dispositive
reasonable
fact according to the
classification?
Florida Supreme Court.
Sorry?
It is the dispositive fact according to the Florida Supreme Court. You don't get to those next steps in the analysis unless it's a local law. I also wanted to just touch base generally about legislative intent. First, there's no need to resort to legislative intent until you find vagueness or ambiguity in the statute. And we know, and there's no dispute, this 16C statute, the only statute that was challenged, applies to only one party, Kendall, and it's a closed class. The legislative intent announced not in the statute, but in the legislation that passed it, in the laws of Florida, announces that they have this intent. If you blow up any of our special giveaways in Section 16, then the whole thing is thrown out. That, again, you don't have to turn to unless you decide that there's some ambiguity that makes you go to legislative intent and look behind the law. If you look at the law itself, and you really do look at the statute in paramateria, it suggests that Kendall should never be approved. It suggests in 395-402-1B that if you have just a level 1 trauma center or just a pediatric center, then no additional level 1 should be elevated. No level 2 should be moved up. And then again in 395.4025, 3D2E, it suggests a new standard for pediatric trauma centers. That is, we want to protect our pediatric standalone trauma centers. They must not have less than 500 high intensity cases. The record is also clear that ever since Kendall's been approved, we've been less than 500. Sorry?
But that's clear going forward. I mean, they have a new system going forward.
The announcement.
But they also recognized, I mean, I think it's clear that they recognized, whether they did it properly, that these people had gone through the system, they expended huge amounts of money. So therefore, we want to deal with those people in this manner, looking backward. No argument with everything you said about going forward.
Yeah, the legislative intent is current, and it applies to how trauma centers should operate, including existing pediatric trauma centers. It is a standard from the American College of Surgeons adopted by the legislature.
If we're looking at legislative intent, isn't the best legislative intent what the statute in fact did? It was their intent. The words say it was their intent that we're going to grandfather these people in.
I would suggest that it's an illegal giveaway. It's a special law that violates the Constitution. As the courts noted, that there were no vested rights. If any party has vested rights, it's Nicklaus Children's that offered a pediatric trauma center with highly qualified and expensive personnel for years. Kendall may have said, we also want this, but that was subject to administrative challenge. That preliminary agency action is still not final. In fact, the case was not closed, but moved over to the Department of Health. It could still be brought alive if this court provides guidance that the means for trying to approve Kendall was, in fact, a special law and unconstitutional. Forgive me, Your Honor, I think there was one more point I wanted to address from the non-severability clause. I just wanted to point out the non-severability clause was at issue in Gulfstream. There was a comprehensive rewrite of the statute in that case. The paramedical industry was specifically rewritten. One specific provision of that gave a benefit to a Ocala, Marion County located parimutuel. That is exactly the same situation we're in here now. We have a revision to the trauma statute. No one argues that it was completely rewritten, but we also have a giveaway, and that's what's being
I'm
challenged.
not, the only thing, this is a kind of friendly question to you. I have no problem that if we found this to be a local law, that the legislature chose for us to strike the whole thing. That's the legal effect of that severability clause. Doesn't seem to me, and I don't think the panel, that severability clause goes any further to make this, make a local law a general law. So, I'm sorry, just take up the rest of your time. I'm going to give you 15 seconds to conclude.
Well, I'll just leave with this. We do think the order should be reversed. This was a general law in its terms, but in fact was a local law. We also suggest that you can determine it's a local law that confers a private benefit. So if you decide it's unconstitutional under Section 10 or Section 11, we think both can be done, and we hope you do. Thank you all.
Well,
Yes, sir.
didn't Mr. Quintero basically lay it out, this whole thing about a private benefit? We don't need to get to, because either it's a local law and unconstitutional, or it's a general law and constitutional, because they didn't give the proper notice. So there's no necessity for even us to go to the private benefit analysis.
If you find the statute unconstitutional because it was in the guise of a local law without notice, then we're okay with that decision. We do thank you.
I understand. I mean, it's just, I understand the argument about a private benefit, but
We've heard an argument today, the description of 16C as being a local law, even though it's not a local law in its terms. So if that definition does apply, then it also can apply to Section 11 and say this is, in fact, a local law that confers a private benefit and is unconstitutional.
okay.
Thank you all.
Thank you. Being no further cases in front of the court will stand at recess.
All rise.